You're married, you've taken vows, shared a life, and built a home. But one night your partner forces himself onto you, ignoring your protests, your fear, your pain. In most parts of the world, this is considered rape. But in India, it isn't. Why? And more importantly, shouldn't be. Today, we dive into one of the most unsettling and controversial aspects of Indian law. Marital rape. A topic that is debated, dismissed, and yet it affects millions of women across the country. So let's break it down legally, socially, and psychologically. Let's start with what the law says. According to section 375 of the Indian Penal Code, rape is defined as sexual intercourse with a woman without a consent. But here's an exception. Under section 375 clause 2, sexual intercourse or sexual acts by a man with his own wife, the wife not being under 15 years of age, is not rape. Yes, you heard that right. Marriage is seen as a perpetual blanket of consent. This exception has been challenged multiple times, but the Indian judiciary has been divided. Here are some of the landmark cases in this aspect. In the case of Independent Thought vs. Union of India in 2017, the Supreme Court ruled that sexual intercourse with a minor wife aged between 15 to 18 is called rape. The court called the marital rape exception unconstitutional under Article 14 and 15, which are the right to equality articles. But here's the catch. The judgment only applies to underage girls. What about adult women? The Bombay High Court said unequivocally in Madhukar Narayan vs. State of Maharashtra that a no is a no, even if the partners have any fiduciary relationship to interest. In Dilip Pandey vs. the State of Chhattisgarh, the court ruled that forced sexual intercourse by a husband does not constitute rape. Similarly, in Hrishikesh Sahoo vs. the State of Karnataka, the court acknowledged the issue but said the legislature must act first. In 2013, Justice Verma Committee recommended that the exception to marital rape should be removed. Marriage should not be considered as an irrevocable consent to sexual acts. Therefore, with regard to an inquiry about whether the complainant consented to the sexual activity, the relationship between the victim and the accused should not be relevant. So why hasn't it? In a landmark judgment of the RIT Foundation vs. Union of India, where there was a split verdict delivered by two judges, Justice Rajiv Shankar and Justice C. Harishankar. As per Justice Rajiv Shankar, marital rape can be considered as rape, and he had observed exception 2 to be unconstitutional. Justice C. Harishankar observed that there are various relationships between a man and a woman, including that of a husband, and the sanctity of marriage has to be protected. Hence, to undermine these relations would be to the ignorance of existing reality. The intelligible differentia under Article 14 was created by marriage. The relationship of a husband and wife has an important incidence of legitimate expectation of sex, and there has to be observed. He mentioned that existence of the Prevention of Women from Domestic Violence Act of 2005, which defines domestic violence as harms or injures or endangers the health, safety, life, limb or well-being, whether mental or physical, of the aggrieved person or tends to do so and includes causing physical abuse, sexual abuse, verbal abuse and emotional abuse and economic abuse. This provision serves to protect victims of marital rape, but it only provides civil remedies such as financial assistance and protection orders, but does not offer any criminal recourse such as imprisonment of the offender. So this judgment resulted in a stalemate, but this shows us the opposing sides of the argument and the court's conflicting perspective on marital rape. To understand why marital rape was never considered a crime, we need to look at history, the doctrine of Coverture. This doctrine, inherited from the British common law, stated that upon marriage, a woman's legal existence was essentially merged with that of her husband. She lost autonomy over her legal rights and property, becoming legally dependent on her husband.
The concept of implied consent by a woman given in the marriage, and a grim reminder of the times of England when women were considered as mere chattels or property and had no inheritance rights.
And most importantly, this doctrine gave the husband control over her wife's body, including sexual relations. It was the very foundation of the marital rape exception. But here's the twist. England abolished this exception in 1991 in the landmark case of R vs. R, recognizing that coverture no longer reflected the status of women in the modern society. Yet in India, this outdated principle continues to linger in our legal system. The British jurist Matthew Hale said that marriage is a legal contract by which a woman gave herself to her husband for life. He asserted that husband cannot be guilty of rape committed by himself upon his lawful wife. For by mutual matrimonial consent and contract, the wife had given up herself in this kind unto her husband, which she cannot retract. Numbers don't lie. Look at this data from the National Family Health Survey 2019 to 21 found that 82% of women who had experienced sexual violence named their current husbands as a perpetrator. 84% of them reported being physically forced into intercourse. These numbers are chilling, but the law remains unchanged. Senior advocate Karuna Nundy argued that the exception under Section 375 violates Articles 14, 15, 19 and 21 of the Constitution. She quoted the Joseph Shine versus Union of India judgment, which decriminalized adultery, stating that familial structures cannot be regarded as private spaces where constitutional rights are violated. So why does the same logic not apply to marital rape? Senior advocate Colin Gonsalves brought into the notice that across the world, 150 plus countries have criminalized marital rape, including Nepal, which declared that criminalizing it purifies marriage rather than destroy it. The UK Law Commission found that no evidence and leads to excessive litigation. So what are we afraid of? The government's view may come as a shock to people. Palke Sharma from Vantage Point brings it to our attention.
And now, for the first time, the Government of India has gone on record and defended their stance. The Home Ministry has submitted an affidavit to the Supreme Court of India.
In October 2024, the Union government filed an affidavit opposing the removal of marital rape exception, arguing that criminalizing it would be excessively harsh and disproportionate. But let's ask ourselves, harsh for whom, the perpetrator or the victim? Centre concluded by rejecting the petitioner's prayers, stating that the implicit nature of conjugal relationships within marriage makes the issue of consent within marriage a matter of complex legislative judgment, which should be approached with caution. In a recent and controversial judgment, the Chhattisgarh High Court acquitted a man. The 40-year-old man was convicted of charges of rape, unnatural sex, and culpable homicide not amounting to murder for his wife's death and jailed for 10 years in 2019. The court's decision hinged on the fact that under current Indian law, marital rape is not recognized as a crime. This case has reignited debates about the urgent need to re-examine and reform the legal stance of India in marital rape. At the core of this debate is a deep-rooted social stigma. In India, marriage is sacred and women are expected to submit themselves to their husbands. The idea that a wife has a right to refuse sex is still seen as radical. We are taught that marriage is about compromise, but should that compromise come at the cost of bodily autonomy? Shouldn't consent be the foundation of any relationship, including marriage? Let's see what Mariam Thawale from AIDWA has to say on the matter.
Now what happens that because it's not recognized as a crime and because there is no form of conviction or no penalty for the husband, then the woman feels helpless as to she cannot get justice in this matter anyway. So she continues to suffer the violence within her home, and it gives an opportunity to the husband. It's a statement of power. It's a statement of trying to subdue a woman.
We talk about Bharatiya Sanskriti, Indian culture, as if it's frozen in time. But culture is what we make it. It evolves. So the real question is, will we evolve with it, or will we continue to ignoring the sufferings of millions of women in the name of tradition? The law isn't just about punishment. It's about setting a precedent. It's about saying this is wrong and we will not stand for it. Until then, the message we send that is marriage is a license, not a partnership. And that is a dangerous precedent to set. What do you think? Should marital rape be criminalized in India? Let's talk in the comments. Like, share and subscribe to Lolly for more legal deep dives. Until then, stay informed and stay empowered. Thank you.